With ammunition regulations back in place, there are still a couple of unanswered questions when it comes to the Rhode v. Bonta lawsuit and the aftermath of the stay that was put in place. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, we are doing a quick circle back on the Rhode v. Bonta case as things continue to be read and they continue to unfold. We want to make sure that everybody has the best up-to-date information as possible. To do that, we have brought back volunteer CRPA President Chuck Michelle. Chuck, thank you for coming back on with us.
Always a pleasure. Thanks for having me, guys.
Wonderful, and thank you again for being here. But guys, before we get into this, it continues to work. The algorithms are working in our favor so long as you are liking, sharing, and hitting that subscription button on all of these videos. Hit that notification bell so that when we drop notifications like this, could be pertinent information for you to have, you will be the first one to have it. So, Chuck, I did want to circle back on a couple of things. One of them we actually discussed in our last video, but as for this, it's kind of like the post-Freedom Week effect that we didn't necessarily have with the Duncan case on the magazine ban because Judge Benitez was pretty specific in his order. Didn't really see that here, maybe because he wanted it to go longer and further than it actually did. But we have the stay that was put on the injunction that we have. We had people for a few days able to purchase ammunition online, get it shipped to their house. Now this stay is put back in place. The law is effectively put back in place, but people have the ammunition that's being shipped over here right now. What do we say for people who are now questioning the legality of this?
First of all, there were two ways that people were buying ammunition. They were going into their FFL's local gun store and buying it and not having to do the background check. And then they were ordering it online, and all of the out of state or online sellers were processing shipments orders as fast as they could. I want to make sure I get the night right. I can't even remember what specific day that stay came down. I think it was Monday. I believe it was Monday at 9 o'clock. The DOJ sent out a bulletin to every FFL in the state saying the ammunition laws are back in effect because the Ninth Circuit has granted the stay on the injunction. So the laws were no longer, the ammo background check and purchase restriction laws were no longer in effect for that period of time, but they were back in effect as at least as of the time that the DOJ sent that notice out. So the bottom line is if those shippers got the stuff in the mail on Monday, you may get it in a day or two, and you should be fine because it was purchased when the restrictions were lifted. But now FFLs cannot sell, and out-of-state or online retailers cannot sell without going through the process that the ammo restriction laws have had in place for the last few years. So hopefully everybody got their ammo while the getting was good during that few days of ammo freedom. And apparently a lot of ammo was sold during that time. I saw some things online where some of the ammunition companies were showing these stacks of orders from California that they were working around the clock to fill. So obviously there's a pent-up demand. Obviously these ammo sales restrictions are slowing people down from getting the ammo that they want for their for sport or to defend their families. So we really have to stick with this and knock this thing out once and for all. And that's what we're hoping will happen next.
Well, as far as that is concerned, you got to look toward the rest of the the rest of the litigation. Excuse me. So we kind of talked about, what we could expect. Something that was included in that expectation was a potential for a merits panel to overturn this stay, similar to what we saw in May. This was a little bit early. We were just getting this decision and reading through it. Now we've had a little bit more time. Can you expand on any expectation that we could have for that and moving forward?
Yeah, well, we've hit a little bit of a snag because in the May case, there was already a merits panel assigned. So when the motions panel granted the stay, the merits panel automatically got it, saw it, and reversed it and put the stay back in effect on the CCW sensitive places restrictions. So your CCW is still good in all the places that it's been good for the last 100 years. But in the Rhode case, there is no merits of panel assigned yet. So we have to try and ask the court, the Ninth Circuit, to expedite the assignment of a merits panel so that we can ask that merits panel to put the stay back in effect. It's a long shot because the presiding judge is an Obama appointee, and I don't think she's going to want to appoint the merits panel early, but it doesn't hurt to ask. And so keep your fingers crossed, but more likely we will be dealing with these restrictions until we get a ruling on the case from the merits panel. I don't know if we have a briefing schedule yet, to tell you the truth. I forget, but because I have so many deadlines and cases being scheduled, I can't keep them all straight sometimes. But in some of the bulletins that we've put out, and you could put a link on the bottom of this video, there's everything that we did in the Rhode case and all the other cases that CRPA is handling is all available to review on the Michelle lawyers back pages where we track all these filings. And folks really ought to take a look at the Rhode case to see what kind of a prolonged scorched earth battle this has been. This is the second time around from Judge Benitez. We won this once already. Now we've won it again. But when it went up to the Ninth Circuit the first time around, it stayed there for a while until the Supreme Court ruled in Bruin. And then all these cases that had been backlogged, bottled up in the Ninth Circuit, were sent back down to Judge Benitez, since he to reevaluate under the Bruin standard, which he just finally did in our favor. But this is the second time around. Folks can see all of these filings. It's been a lot of work, and there's going to be significant amount of work to come. So we really need folks to support the CRPA in this and all its other Second Amendment cases. And for that matter, the Second Amendment Law Center to do the amicus campaigns that's going to be needed on Rhode and all these other cases.
Yeah, and Jacob, we should absolutely put that link in the comment the description section below. So if you want to see that, go ahead and check that out down there. It is a long list of things. We talk about the decisions and we talk about the hearings and all of this stuff, but the fact of the matter is that is just a fraction of the work that goes into any of these lawsuits, all the deadlines, all of the the research and the briefing that has to be done. Those are the things that we don't even cover on channels like this. But
just all the forms. I mean, people hear about the motions and the arguments, but the day-to-day or week-to-week administration of these cases is labor intensive. I mean, CRPA gets a great nonprofit rate for its legal fees, but it still takes time. And people, I think, if they look at that list of things that have been filed, will really appreciate all the work that goes into all these lawsuits and why we so badly need people to support us so we can keep the balls rolling in our favor and take back some of the rights that have been stolen from us for the last couple of decades by the anti-gun politicians in Sacramento.
Yeah, I couldn't agree more. But let me just circle back to this so that I can get this straight. It almost sounds like you're saying that there's a piece of the puzzle that we had in the process of getting the May stay overturned that we don't have now. So in the May case, there was already a merits panel that was in place. What we asked for was to expedite the review of the stay that was put in place on our injunction for sensitive places. Now, we got our injunction here on the ammunition regulations, but there's nobody to request to expedite this review to, because there is no merits panel existing to review this yet. So another piece of the puzzle that we're going to have to find. Having said that, Chuck, I know you said that the outlook as far as scheduling is concerned is a little bit of an unknown right now for you, but what about just the overall outlook of the case? What are your final thoughts on this moving forward?
Well, this case and every other case being litigated by every pro-Second Amendment civil rights group across the country, not just CRPA and not just California and not just Ninth Circuit, it's all the battle that's being fought is over what the proper methodology, what the way to apply the Bruin methodology is. States who are being assisted by billionaire Michael Bloomberg's group, Everytown Law. I mean, they have some of the highest paid lawyers in the country working for them to try and come up with creative arguments to twist the Bruin methodology so that more laws will be found to be constitutional, just like they did after Heller. They didn't follow the Supreme Court's instructions in Heller, and they're trying not to follow what I think are crystal clear instructions in Bruin. Test text. Is it covered by the language of the Second Amendment? And then is there a historical law that indicates the founders would have tolerated a modern day law? They want to fight about what is an arm, whether only self-defense arms are covered, whether magazines are covered or accessories, or the right to buy or sell, or the right to go to a range. All of that stuff, they want to say it's not included in the text of the Second Amendment. Well, it is, and the Supreme Court says it is, but they go around that, try and argue around that. And some judges that may be a bit pre-inclined to try and want to uphold the gun control law are adopting those kinds of arguments. So all of these cases, it depends on whether or not we can get the courts. And in the Ninth Circuit, it's split. Some of them definitely get it and are applying the methodology faithfully, the way the Supreme Court intended. Others are not. And so the Duncan case is probably the one that's furthest out in front. They're in front of an en banc panel already. That en banc panel is going to have to address this methodology question. And however they do that, it's either going to have to go to the Supreme Court, or all of the cases that are bottled up behind Duncan will be now evaluated under whatever the Duncan standard is. And hopefully it adopts the Bruin standard the way it was meant to be applied, and we win.
Well, and it seems like the opposing side has their work cut out for them for all the money that those attorneys are being paid. I've been watching a lot of these arguments, and it seems like some of the best ones that they can come up with are laws from the analogs of history that have to do with some sincerely discriminatory practices. So if that's the best that they can come up with, I think that's more reinforcement that Bruin was written in a very good way to make sure that we keep our rights moving forward with a lot of this, with a lot of these lawsuits. Chuck, I know you're a busy guy. I know you're doing a lot of work on this. I want to thank you again, and thanks for coming on.
Thanks for having me, guys. And folks, please do what you can to help us out. We'll keep fighting for your rights. We just need the ammo to do it.
So guys, if you like these videos and you like content like this, go ahead and drop a like, subscribe to the channel, share these videos, hit that notification bell so that we come out with these videos. You are the first one to be informed. We want to make sure, especially in an election year, that everybody is armed with the right information so that we can continue and progress this Second Amendment movement. Thanks again, guys, and we'll see you on the next one.